Hi everyone, welcome to my channel. If this is your first time seeing my face, I am Jaleesa, your friendly neighborhood lawyer. And if you are a returning subscriber, welcome back, my alien ally. Nice to have you here. Today's video is episode 2 of my Alien in the Courtroom series, aimed at helping young entrepreneur and young startups at making better legal decisions for their brand. Today's video is all about picking a strong business name. Coming into 2020, into the new year, we always want to create a new business. We want to form a new stream of income. I get it, but we want to make sure that whatever name we're picking or choosing, that it has some strong legal backing to it in the future. When that time comes around that your business is making thousands of dollars or millions of dollars, you want to make sure that you are protecting your name and that no one else can use your name. That's what today's video is covering, and it's possibly a little bit of a warning why you shouldn't use your own personal name as your business name. So if you would like to hear more about this, then just stay tuned. It's important that I stress that this information is intended for educational purposes only. In no way should you consider me to be your own lawyer. I try my best to answer any questions that are in the comment section. If I feel like the questions are getting too close to giving you legal advice, then I probably will refrain from answering that question. And I encourage you to seek outside representation, seek legal counsel if you have any of those specific kinds of questions. But in the meantime, you can always leave your questions in the comment section, and hopefully that could be my next video. So feel free, drop a comment, leave a question, I'll get back to you. So I have my laptop in front of me just to make sure that I give you the most accurate information possible. And let's start our discussion with a little refresher on what trademark law is. Because when it comes to naming your business, we're referring to trademarks. I previously talked about the difference between trademark, copyright, and patents in episode 1 of this series. So if you would like to have more in-depth discussion or information about that, you should go ahead and check out that first video. But just for a refresher for this course, trademark law refers to a word, phrase, symbol, product shape, or logo by a manufacturer or merchant to identify its goods and distinguish those goods from those made or sold by another. So in trademark law, words, phrases, symbols, slogans, product shapes, logos, all of that is usually referred to as marks. So if I use the word marks in this video, just know that I'm talking about trademarks. It is a mark that helps customers know that that product is a part of your brand. But one thing I didn't say in the first episode that I'm letting you know now is that there is no such thing as trademark rights in a word. So what a trademark really is the use of the word in connection to a particular good or service. Rise and shine, Kylie Jenner. I can't just trademark the words rise and shine. I have to trademark the words rise and shine in relation to clothing, like what she's trying to do now. So when you apply for a trademark, you have to say what the words or phrase or logo is and what's the products that are being sold. A trademark equals word plus the product/service being sold. Trademarks are also usually defined into categories called classes, and practically anything you can think of, it fits into a class. I believe that there's 45 classes totals. Class 14, for example, is jewelry products. Class 25 is all clothing, including footwear and headwear. And influencers, for example, may want to trademark their name under advertising services, promoting brands, goods and services of others, and endorsement services. And because trademark is defined by classes, that's the reason why brands can have the same name. So you think of Dove soap. Dove soap is not owned by the same people who do Dove chocolate. Two different brands, two different products, but the same name. So now that we've gone over a little bit of the basics of trademark law, let's talk about how this relates to your business and picking out the best name possible for your business so that you can have the greatest protection against thieves, okay? Today's lesson is really about spectrum of marks. Every trademark that exists on a spectrum of marks. Trademarks are usually categorized into 4 different strengths. Think of it as having a weak password versus a strong password. It's a spectrum of marks. So those marks, those 4 categories are fanciful / arbitrary, suggestive, descriptive, and generic. And the further down you go, the further you get to being generic, the more necessary it is for other companies to use that word, meaning that you cannot trademark that word. So for example, you can't trademark the word shoes in relation to your footwear line because other companies need to have access to the word shoes. You are not the only shoe company out there. The higher or the closer that you get to fanciful and arbitrary is the less necessary for producers or companies to use that word, which is a good thing. Fanciful words are made up words. They're words or symbols that have nothing to do with the products or services being sold. So think maybe Exxon, Rolex, Kodak, Xerox, Google, Reebok, Polaroid. Those are all words that are made up. They are not a part of the English language, but now they're so popular that we all know what it means. We know that Google is a search engine. We know that Reebok is a shoe company. We know Polaroid, it refers to pictures. Arbitrary is a word with significance recognized in everyday life, but instead of signifying that particular thing, it signifies something entirely unrelated to the product or service to which the mark is attached. That was a mouthful, but just think of it as using a word that has nothing to do with the service. So Apple for Apple computers. Apple is a word in the everyday English language, but it has nothing to do with technology, computers, or any of the services that Apple actually produces and creates. Think BlackBerry for phones. BlackBerry is a fruit. It has nothing to do with actual phone. So those are words that are recognized in everyday life, but they have nothing to do with the actual product. Then we go on to suggestive and descriptive, and there's a little bit of a difference between these two, not to get too heavy, but suggested means the term has something to do with the products being sold, that the term suggests a feature or characteristic of the good, but it requires a bit of thought and an imagination to determine what the goods are. So an example of this is Microsoft. Microsoft is indicative of software. The soft in Microsoft might lead consumers to believe that it's about software, and micro, maybe microchips. Maybe you can make that imaginative leap. It suggests what the product is. And Greyhound buses. So we know that Greyhounds are fast animals. So this might suggest that their buses are fast, like they're a fast means of transportation. There's a little bit of a leap before you get to where you need to be. Now there is descriptive, which means that the term directly describes something about the product being sold. They describe a characteristic, an ingredient, a quality, a feature or purpose of the good or service. So we can think American Airlines. American Airlines is exactly as it states. It's an airlines in America. And lastly, generic, which is the strength that you want to avoid, the weakest strength possible, refers to terms used to name products or services. So a brand calling themselves shoes. You're not going to have any success trademarking your name shoes because every company out there needs to have access to the word shoes. If you're selling phones, you can't trademark the word phones. If you're selling pens, you can't trademark the word pens. That's pretty much self-explanatory. So if a word is far off from the product, the consumer will most likely think that word identifies your specific company. You really want to make sure that whatever business name that you choose, maybe it's completely random, maybe it's not really so suggestive of what your company or brand is producing. You really want to make sure that you have a name that's in the fanciful, arbitrary, suggestive categories compared to descriptive and generic categories. And lastly, I just want to go over the issue of naming your business after yourself, your personal name. And this typically comes up when you're using a surname or an eponymous name, which just means your full name, like Jaleesa Johnson, my full name. This is when these issues typically arise when using your own name. You can use your first name. There's actually a skincare line out there called Jessica, because I mean, you might just want to name your brand after yourself. It makes complete sense. I can see influencers doing this. But the United States Patent and Trademark Office, which is the office that would register your trademark nationally, has a little bit of an issue if your mark is primarily a surname. To get a trademark in that has a surname in it, the examiners would have to look to whether the mark is primarily a surname, and if so, whether it has acquired distinctiveness. I don't want to go too far into what distinctiveness means, but you can just think of it as popularity for now, whether it's acquired enough popularity that consumers are not likely to get confused on that name belonging to that company. Examiners will look at factors such as whether the term and the surname inside the term, whether it's rare, whether the term is the surname of anyone connected to the applicant, whether the surname is actually the surname of the applicant, whether the term has any recognized meaning apart from being a surname, the look and feel of a surname, whether the mark has a unique text stylization that creates a distinct commercial impression. All of those factors are going to be considered when you sign or apply for a trademark with your last name in it. But we can think about companies that have actually succeeded with getting their surname trademarked. McDonald's is the big one. When McDonald's was being trademarked, it wasn't by the McDonald brothers. I believe it was Ray Kroc who owned McDonald's at that point, and he was the one that was going about and making sure that McDonald's was legally secure. Kellogg's is another one. The cereal brand, they own a lot of different things. It's probably not just cereal. And one interesting thing to note is if you have a partner that you want to get into business with, a combination of multiple surnames isn't that bad. It's not usually considered a surname. Johnson & Johnson is not seen by the USPTO as a surname. And a lot of bakeries and restaurants sometimes go by like Bob's Burgers, Allen's Bakery. Those kind of names have issues when it comes to the trademark office. I think it's really up in the air. It really just depends on the factors that I stated before, how rare it is, the look and feel. Maybe the logo has some interesting text that makes it really distinct to a consumer's mind. You'll have more of a fight with the trademark office if you choose to use any of those kinds of names. When it comes to eponymous names, like naming a brand Jalisa Johnson, I think you find eponymous names when it comes to fashion very often, like think Louis Vuitton, Christian Siriano, think Stuart Weitzman. Designers in general just like to name their collections after themselves. Not to say that this is a bad thing, but I just want to make you aware that if your business ever does make it really big and you're making thousands, millions of dollars, when it comes time to sell your business, that it's possible that you are losing your own name. When you sell your business to a third party, you have lost the rights to your name. I think some contracts allow for you to use your name if it's for educational purposes. Some of the contracts may have like a little stipulation in there for that. But if you ever think about using your name again to start a similar company, you're in trouble. Popular example of this is JA Apparel Corp versus Abud. I don't know how to pronounce this designer's name. I think it's Joseph Abud. I'm just gonna call him Joseph A. Joseph A sold his company and the rights to his name to JA Apparel in 2000. And then later on, he decided that he wanted to create a new menswear line. He chose to call the new line Jazz, which was fine, but he wanted to use the tagline, a new composition by designer Joseph Abud. That tagline is the issue. JA Apparel is going to come after JA for trying to use his name to brand and market his new menswear line. You just want to be aware that whenever you use your own name to describe your company, that you are possibly signing over your rights to your name in the future at a later date down the line when your company is blowing up and making millions of dollars. You sold it, now you want to go back into the same business again. Now you don't have the right to use your name. Now you got to find creative ways to market it, and you don't get to build off the success of your first business. When a designer can no longer use his name or likeness, they can consider alternative ways of identifying themselves as the designer of their new brand. So they can do things like press releases, third-party websites like blogs, but maybe even in your website's About Me, keyword advertising, social media posts, domain names, even changing your name legally could be another step for you. Kate Spade actually renamed herself Kate Valentine Spade, and that was for the sake of putting out a new line under Kate Valentine. With all of that being said, that brings us to the end of this episode 2 of my Alien in the Courtroom series. Hopefully you can take this information with you into 2020 when it comes to naming your new business and thinking about better legal protection in the future. If you have any questions or comments, please leave them down below in the comment section. I will love to get back to you, and maybe your question can be my next video. Thank you so much for watching. Give it a thumbs up if you enjoyed, subscribe, share it with anyone that you know that is starting a brand new business. This is information that he or she definitely needs to know. And I'll talk to you guys in the next video. Bye.